12 September 2019 with the same offense, similar facts. And she entered a plea of not guilty. 12 September 2019. An application for bail was made by the accused person on 16th September 2019. And in opposition to that bail application, the prosecution presented an affidavit by the same Mr. Officer Maxwell Otieno, a 52-paragraph affidavit dated 18th September 2019. My lady, this matter was placed before your learned sister, before your sister. Justice Motuku. I've attached the ruling of that bail application. My lady, this matter. And in her wisdom, the judge summarized the compelling reasons. Yes, I will refer you, my lady. That's fine, my lady. It was not properly numbered. I'll refer you to page 5. From the page 4, determination, from the last paragraph. The learned judge highlighted the compelling reasons picked up from the affidavit and from the prosecution of Maxwell Otieno. My lady, the first one, the learned judge addressed the issue of flight risk, the issue of fixed abode. She made findings on the interference with witnesses, interference with investigations, public disturbance, and trivializing of the trial. Those were the grounds the opposition relied on to demonstrate compelling reasons to deny bail. My lady, this morning, the affidavit that has been filed by Maxwell and the submissions by the prosecution is that there are two principal grounds that they want you to have a look at and deny the accused person bail. The first one is interference with witnesses. My lady, we filed a replying affidavit in opposition. It's signed by the accused person on 31st January 2015. Oh, yeah. She's made, she's responded to each and every allegation raised in the affidavit, and my lady, I know when you retire, you'll have a look at them. But you've been referred to a statement of a protected witness. And my lady, if you allow me, I will read out the relevant part. It's appearing at page 2 of the exhibit marked MO2. This is one of the vulnerable witnesses. And this is what he said. That, my lady, dates are really important in my submissions. On 14th September 2019, at around 7 p.m., one Mr. Murgor came to our residence. The main gate was closed. He stood by the gate and called the policeman who were guarding the premises and told one of them to call us for him. The police came to where we were and told us that we had a visitor. We proceeded to the gate area and I met him. He formally introduced himself as Mr. Murgor and the lawyer advocate for my employer, Sarah Wairimo. He told us that on Tuesday at night, 10th September 2019, Mr. Otieno had instructed, or rather ordered us to lock up ourselves inside our room and not to come out during the night. I told him that nothing of that had happened and that at no time were we given such orders. He then suggested to us that at the same time, we had been instructed by Moirore to leave the premises and return to our rural home. My lady, first of all, this testimony is hearsay. Second of all, this is in 2019. This statement contains elements of criminal acts. My lady, the Office of the Director of Public Prosecution and the DC are obliged to investigate these allegations. As we are here before you, my lady, the prosecution has been sitting on this statement since 2019. No investigations, no material about the investigations as to the contents of this statement and the possible criminal elements have been produced against Mr. Murgo. The testimony says that there's a Mr. Murgo who came to try to interfere with them. Mr. Murgo was acting for the accused person in the previous case. Yes, my lady, there's no investigation that has been undertaken by the ODPP or the DCI with respect to the criminal elements apparent in this statement. My lady, this statement points to circumstances of obstruction of justice, interference with witnesses. These are serious allegations that ought to have been investigated. Now, my lady, before you right now, bail application on the compelling reasons. The standard of proof is on a balance of probability. In the event that this statement were and the material are with the ODPP, is it not probable that they ought to have investigated this and point to the accused person? Would such a statement be severe enough to deny an accused person fundamental right to bail in the circumstances? My lady, the submission before you, Father, on the interference of witnesses is that these witnesses are under the Witness Protection Program. My lady, the Witness Protection Program is designed and is actually from an act of parliament and is designed to protect witnesses in trials who are deemed to be vulnerable.